Greetings and welcome to this presentation from the CDSS Civil Rights section on the topic of the Americans with Disabilities Act and reasonable accommodations. We'll start the presentation by going over our key learning objectives. Then we'll provide an overview of the legal framework that exists to protect the rights of individuals with disabilities and ensure they have meaningful access to public benefits and services. Next, the presentation will explain who is protected under the ADA. Then for the remainder of the presentation, we'll cover key concepts, procedures, and requirements for providing reasonable accommodations to individuals who need them. Our goals for this training are to build understanding of the following: the requirements for equal access for people with disabilities under the ADA and other disability rights laws, what a reasonable accommodation is and how to respond to a request for one, and what the requirements are for effective communication with people with disabilities. We'll also highlight key resources provided by CDSS to assist counties in meeting these requirements. Let's start with a quick overview of the legal framework. There are several laws and regulations that prohibit discrimination against people with disabilities. This presentation is going to focus on three main sources of legal authority that apply to government agencies, including county welfare departments. The first is Title II of the Americans with Disabilities Act and its regulations, which are found at 28 CFR Part 35. These apply to state and local government programs and services, including county welfare department public benefits programs. The next is California Government Code Section 11135 and its recently revised regulations found in the California Code of Regulations, or CCR. These incorporate Title II of the Americans with Disabilities Act and prohibit discrimination based on many categories, such as race, sex, national origin, and disability. The revised regulations help clarify and strengthen protections for individuals with disabilities. Last are specific regulations and guidance from CDSS. CDSS civil rights regulations are found in Division 21 of our Manual of Policies and Procedures, or MPP. They include a section on accessibility, which doesn't say very much, but what it does say is that county welfare departments need to follow the ADA Title II regulations. Key CDSS guidance on the topic of reasonable accommodations can be found in a few specific all-county letters, or ACLs, with more to come. ACL 1945 explains in detail what steps county welfare departments must take to meet their obligations regarding disability access and reasonable accommodations. ACL 2178 is a program-specific ACL that explains best practices for ensuring disability access in CalFresh. ACL 2465 is a similarly program-specific ACL that addresses disability access, including reasonable accommodations in CalWorks. ACL 2467 covers the same topics for RCA, or Refugee Cash Assistance, ECA, Cuban and Haitian Entrant Cash Assistance, and TCVAP, the Trafficking and Crime Victim Assistance Program. CRS is continuing to develop additional program-specific ACLs on the topic of reasonable accommodations as well. And a separate upcoming ACL will focus specifically on documenting reasonable accommodations in the CalSAWS case management system. And one more item to mention here. Our office and the Office of Deaf Access recently jointly issued ACIN I-3924 titled Reminders of Civil Rights Obligations to Individuals Who Are Deaf and Hard of Hearing, which includes guidance on the reasonable accommodation obligations. Next, we're going to talk about who is protected by these disability discrimination laws and regulations. First, it's important to note that many programs, for example, CalFresh, CAPI, the Cash Assistance Program for Immigrants, CalWorks, IHSS, the In-Home Supportive Services Program, and SSI, have their own definitions of who is considered to have a disability. The ADA's definition is different, and the protections described in this presentation apply to anyone who meets the ADA definition, regardless of whether they are considered disabled under a program definition. Let's look specifically at the ADA's definition of disability. The ADA, which is federal law, defines disability as a physical or mental impairment that substantially limits a major life activity. Some examples are listed on the slide here. Physical disabilities can include sensory impairments like blindness or low vision, deafness or hearing loss, or speech disabilities. They can also include mobility impairments, arthritis, cerebral palsy, cancer, heart disease, HIV. Examples of mental disabilities might include autism, Down syndrome, major depressive disorder, anxiety disorder, bipolar disorder, PTSD, ADD, and learning disabilities. An important thing to note here is that the California legal definition under California Government Code Section 12926, as well as some other state laws, is even broader than the definition of disability under the ADA. California law includes any impairment that limits a major life activity. There's no requirement for the limitation to be substantial, as in the ADA. The important takeaway here, though, is that both definitions, the federal and the California law definitions, are meant to cover and protect a broad range of disabilities. And in California, the protections are even more expansive. This means that we shouldn't spend a lot of time trying to determine whether a person legally meets the definition of disability, because so many individuals will meet the threshold of having a condition that limits a major life activity. The focus really needs to be on determining what the person's needs are and how best to assist them. The ADA Title II says that no qualified individual with a disability can be denied equal access to the programs or services of a government agency. A qualified individual with a disability is a person with a disability, defined in the previous slide, who, with or without reasonable accommodations or the provision of auxiliary aids and services, meets the essential eligibility requirements for the receipt of services or participation in a program provided by a public entity, such as a county welfare department. That was a mouthful, so let's stop to restate this another way. Because of their disabilities, some people may need extra help to meet certain program requirements or to participate in that program or service. For example, someone with low vision might need a large font application form, or a person with a particular mental or physical disability might need extra time to submit required documentation. The ADA says that these people have a right to receive this extra help from the agency that is administering the program or service. The agency can't say that the person doesn't qualify, isn't eligible, or is non-compliant with participation requirements just because they need that extra help. That extra help is known as a reasonable accommodation, or sometimes an auxiliary aid or service. So what are the reasonable accommodations and auxiliary aids and services that qualified individuals with disabilities are entitled to? What do these terms mean? Let's start by taking a closer look at what a reasonable accommodation is. ADA Title II actually uses a different term, reasonable modification. But for purposes of serving individuals with disabilities in county programs, the term reasonable modification and reasonable accommodation are pretty much interchangeable, so that's the term that we use throughout this presentation. The ADA says that counties must make reasonable accommodations to their policies, practices, or procedures when necessary to provide equal access to persons with disabilities. So broadly speaking, a reasonable accommodation is basically a change in the way that a county usually does things in order to help a person with a disability to access a program or service. It could take many different forms. There are probably as many kinds of reasonable accommodations as there are individuals with disabilities. Some examples could be waiving a program rule or deadline, providing somebody with extra help in understanding and completing forms, giving extra phone calls or other reminders of appointments or program requirements, providing documents in alternative formats like Braille or large font for people with low vision, allowing a family member to help in a telephone interview, or assigning someone a specific caseworker even if your county doesn't work on a caseworker-specific system. The list can go on and on and on. This next slide shows a chart that is based on one used by the Massachusetts Department of Transitional Assistance to illustrate both the challenges or barriers a client with a disability might face in accessing programs and benefits, and the range of reasonable accommodations that can be made to help ensure they have equal access. The first column lists the barriers a client with a disability might face in trying to meet expectations or requirements, such as difficulty in understanding notices or getting verifications, meeting program deadlines, or coming to the County Welfare Department or CWD office. The middle column lists examples of some of the disabilities that might cause the person to experience those difficulties. And the third column lists examples of accommodations a county welfare department could provide that might ensure equal program access for the individual with a disability. Although not meant to be exhaustive, your county welfare department can consider developing a chart like this as a job aid. It can help staff with the task of receiving and processing common accommodation requests, and it can help them offer appropriate accommodations to overcome common obstacles. It's important to note here that a client with a disability may need, and the ADA may entitle them to, a rule modification to a program, activity, or office location. The example here is of a person whose disability, diabetes, requires them to eat frequently to maintain their glucose levels. If their county welfare department office has a rule against bringing in and eating food, this could cause an access barrier for this person. Therefore, the county welfare department may need to waive that rule to accommodate the client. Now, there are a few specific limited circumstances under which a county welfare department can deny a reasonable accommodation request, which we'll talk about in more detail in an upcoming slide. The main point to understand here is that the universe of possible reasonable accommodations that clients are legally entitled to is very wide. Each reasonable accommodation request from a program applicant or recipient with a disability needs to be considered from that perspective. Now we'll take an even closer look at reasonable accommodation requirements. We're going to break down what a county welfare department's obligations are towards individuals who need reasonable accommodations, and how county welfare departments should respond to these needs. The first issue we'll cover, a natural starting point, is the county welfare department's obligation to provide notice or let people with disabilities know that they have a right to a reasonable accommodation. The next issue we'll talk about is when a reasonable accommodation request is made, how does the county welfare department determine if the person making the request is a qualified individual with a disability? After that, we'll talk about the reasonable accommodation request itself, that is, what it looks and sounds like, how and when these requests are made, and what county welfare department staff should be paying attention to. Then we'll talk about the nexus or link between the disability and the requested accommodation and why that's important. After that, we'll discuss what the ADA says about reasonable and unreasonable accommodation requests, including who gets to decide and how. Then we'll explore something called the interactive process, what that means and how it's done. Next, we'll talk about documentation requirements, which are extremely important both to ensure individuals with disabilities get the services they need and to ensure that the county welfare department can demonstrate that it's meeting its legal obligations under the ADA. And last, we'll talk about county welfare department policy and staff training requirements when it comes to providing services, including reasonable accommodations to individuals with disabilities. So the first requirement to know about is providing notice of the right to reasonable accommodations. The ADA and other laws require that county welfare departments notify all clients and prospective clients of the right to ask for a reasonable accommodation and the protections they're entitled to against discrimination on the basis of disability. There are lots of ways to provide notice, including putting up posters in the lobby, distributing the Pub 13, which includes a notice about disability discrimination and reasonable accommodations, posting notice on your county welfare department's website, and providing verbal notice. County welfare departments are required to train public contact staff, program managers, and supervisors on their policies for ensuring compliance with disability non-discrimination laws and on providing reasonable accommodations for people with disabilities. We'll talk more about staff training at the end of this presentation, but it's worth mentioning here that county welfare departments should consider providing training that includes some example scenarios or scripts for staff to use when providing verbal notice or offering extra assistance to clients. Here's an example that can help illustrate why it's important to think about providing notice in a variety of ways. Imagine a program applicant who has dyslexia, which is a learning disorder that disrupts how the brain processes written language. Dyslexia causes difficulty with reading and related skills. It doesn't have anything to do with a person's intelligence, but it can make reading comprehension challenging. So for someone who has dyslexia or any disability that causes reading difficulties, it's important that this notice of the right to reasonable accommodation is provided in plain language and that it is given verbally by staff as well as in writing on posters and in pamphlets. The next requirement to understand involves identifying whether someone is a qualified individual with a disability. As explained earlier, the ADA, Title II, and California law provide protection against discrimination for qualified individuals with disabilities, meaning people with a physical or mental impairment that limits a major life activity. Remember, this definition is intended to be very broad and inclusive, and it's different from how disability is defined for disability-related benefits, such as SSI and other programs. So county welfare departments need to use the ADA definition when considering whether someone is eligible to receive a reasonable accommodation. Determining that somebody has a disability under the ADA is very often straightforward because some disabilities are obvious. An example of an obvious disability is an individual who uses a mobility device. Some disabilities are referred to as invisible disabilities because they're not apparent. For example, a mental health issue. A person with an invisible disability might disclose that they have a disability to the county welfare department worker, or they might not for various reasons. Sometimes a client may not even be aware that they have a disability. They can still qualify under the ADA's definition and protections. In those cases, it might be necessary for county welfare department staff to help the person identify that they have a limiting condition and a need for a reasonable accommodation that's related to that condition. When a county welfare department has actual knowledge of a person's disability, or when the person's need for a reasonable accommodation is obvious, the county welfare department is required to offer to assist them in self-identifying whether they have a disability-related need for an accommodation. We'll talk more about reasonable accommodation offers and requests in upcoming slides. For now, the important thing to understand is that there's more than one way to identify someone as a qualified individual with a disability. The burden does not fall solely on the client to announce that they have a disability or that they need a disability-related accommodation. Note also that they are not required to provide a specific diagnosis or medical documentation to qualify under the ADA, and county welfare departments should not ask for this information when determining a person's eligibility under the ADA. However, county welfare department staff can ask the person to clarify what type of help or accommodation they need, for example, by asking, "What activities are difficult for you?" Or they can ask what the link is between the person's disability and the requested accommodation. For example, by asking, "Can you please explain how this accommodation will help you?" Think about our example of a person with dyslexia. This is potentially one of those disabilities that might be invisible to a county welfare department staff person. You can't tell upon seeing or meeting someone that they have dyslexia. But we know that it's a neurological impairment that limits the major life activities of reading and other language-related tasks. So if a person discloses they have dyslexia, that triggers the county welfare department's obligation to offer reasonable accommodation. But take a different example. A person might tell a worker that they have difficulty keeping track of deadlines or other important information, and they may ask for help with those tasks without using the word disability or having a formal diagnosis. They may have a condition such as ADHD that is undiagnosed, but they can still be aware of having and share that they have a limitation and a need for extra assistance with certain tasks. That should be understood and treated as a reasonable accommodation request. Whatever way the issue comes up, the worker must offer to assist the client in discussing what type of reasonable accommodation they might need. This issue can arise in a variety of ways, and county welfare departments should train their public contact staff on how to respectfully initiate reasonable accommodation offers and inquiries using example scenarios and suggested language. Examples like these are widely available on the internet. The next two slides list some example scenarios involving a known or obvious disability. Let's take a look at each of these. The person might use a mobility device or be assisted by a service animal. They might request an auxiliary aid such as large print or ASL interpretation. They may have a case history that indicates a disability, such as receiving or having a history of receiving disability-based services such as IHSS, disability-linked Medi-Cal, or regional center services. The person may report receipt of an income source for people with disabilities, such as SSI, SSDI, SDI, or CAPI. The individual may verbally state that they have a disability. They may say they have trouble with a major life activity even if they don't use the word disability. For example, I have trouble remembering things people tell me, or I have difficulty moving around. They indicate on an application or redetermination or other form that they have a disability or need assistance. Or the person may request a disability-based exemption from welfare to work. County welfare departments also have the option of using affirmative screening for all applicants and recipients. Affirmative screening could take place at intake and would help ensure that individuals with disabilities are identified and receive needed accommodations. In addition, using affirmative screenings with all clients can help reduce pressure on staff to make difficult judgment calls and help them navigate potentially sensitive conversations. This next slide shows a sample affirmative screening script based on one shared by Greater Boston Legal Services. The worker would read the script aloud like this. There are things the County Welfare Department will ask you to do in order to get or keep your benefits and services. If you have a health problem that makes it hard for you to do something this office asks, you can ask for help. This is called an accommodation. This could be because of a physical or mental or emotional health problem. So some of the things we'll ask you to do are to read notices we send and follow instructions in them, fill out forms, come to the office for appointments, get and give us documents to prove whether you can get benefits, tell us about changes in your household or case, and meet deadlines. Do you think you might need help with any of these things or something else because of a health problem? As you can see, this script is framed around tasks that an individual might struggle with due to a disability, rather than on the disability itself. This approach can help individuals to more easily identify if their disabilities could affect their ability to apply for or participate in a county welfare department program. This approach also helps the county welfare department identify and respond to those individuals with reasonable accommodation needs. This script makes clear that individuals with mental as well as physical disabilities are entitled to reasonable accommodations. One thing to note here while we're talking about giving notice of the right to reasonable accommodation and offering reasonable accommodations, an offer is just that, an offer. Under no circumstances should a county welfare department unilaterally impose an accommodation on a client. The client may not agree with the solution proposed by the county welfare department. For example, a county welfare department can't just automatically provide an ASL interpreter for clients who are deaf or hard of hearing because not all such individuals know how to communicate using ASL. Or the individual may not feel a need for an accommodation at all. Either way, the reasonable accommodation process must be client-driven and client-focused. We'll talk shortly about the interactive process that's required when the client and the county welfare department disagree about a particular reasonable accommodation. An important note here about individuals with disabilities protected by the ADA. The right to reasonable accommodation applies to individuals in child welfare and IHSS cases as well as those in eligibility programs. Parents, foster parents, and legal guardians with child welfare cases are entitled to reasonable accommodation, as are the children in those cases. Also protected are prospective parents. There will also be situations where the person with a disability is not themselves a program participant, but they're the one that the worker interacts and communicates with. These individuals are also entitled to reasonable accommodation provided by the county welfare department. For example, non-aided parents or guardians, such as the parents of a child receiving CalWORKS benefits. Companions, for example, friends or relatives or authorized representatives who assist someone with their case. These individuals can be authorized representatives, but they're not required to be to qualify for the protections. An individual visiting a county welfare department office for information about a program is also entitled to reasonable accommodation. Let's continue to the next issue from our earlier list and talk more about how and when reasonable accommodation requests can be made. First is the how. There's no formula or set of words needed for requesting a reasonable accommodation. Whenever a person asks for extra help or a change to program rules or a change to the county welfare department's standard practices because of a disability, this is a reasonable accommodation request. These requests can be verbal or written. County welfare departments can make a form available for individuals to request a reasonable accommodation, but cannot require anyone to use that form. Requests can be made in person, by phone, by email, by text, by letter, by note, by carrier pigeon. The point is that reasonable accommodation requests can be made in many ways. The person making the request doesn't have to use any specific or magic words. They don't have to say the words reasonable accommodation when making a reasonable accommodation request. Because of this, it's sometimes going to require some common sense and listening by the worker to identify that what is being asked for is a reasonable accommodation. This is again why staff training is so important. Another thing to note, a third party can ask for a reasonable accommodation request on behalf of an applicant or recipient. This is different from the use of an authorized representative. A person does not have to be an authorized rep to request a reasonable accommodation on behalf of a CWD client. They can just be a companion. They don't have to have filled out any kind of specific paperwork. The ADA is very expansive about who can make a request on behalf of someone else for a reasonable accommodation. Let's go back to our example of the client with dyslexia. This person who has trouble reading and understanding written documents does not have to tell a worker, I have a learning disability, or I have dyslexia and I am requesting a reasonable accommodation. They might do that, but they might also say, I'm having trouble reading this. Can you help me? Or I don't understand written forms very well. Can you read this form to me and explain what it says? Any of those or other ways of asking for help are perfectly valid reasonable accommodation requests. The person does not have to say the magic words reasonable accommodation or even the word disability. Now we'll focus on when a person can make a reasonable accommodation request. This is an easy one to remember. A person can ask for a reasonable accommodation at any time. It does not have to happen at an intake interview or when their case is first opened. Think about it. A person's circumstances can change, their health status, their need for disability-related assistance. A person might discover that they have a problem or issue that they weren't aware of before. Or maybe they knew about it but didn't realize at first that they could get help in dealing with it, or that they have a right to a reasonable accommodation. Some examples of when a person might ask for a reasonable accommodation are during screening or application, after denial or acceptance of benefits, while they're receiving benefits, including at redetermination, when benefits are terminated, including during fraud investigations or fraud referrals, or during the fair hearing process. A county welfare department cannot deny a person a reasonable accommodation just because the department thinks they should have asked for it earlier. There's never a wrong time to ask for an accommodation. There's no time limit. Let's think again about our example of the person with dyslexia. Let's say they didn't ask for an accommodation when they first submitted their application, but now it's time for redetermination and they're saying they have dyslexia and need additional assistance. Isn't their time up to have asked for this accommodation? The answer is no. There's never a wrong time to ask. You may be wondering, are there any limits to granting a reasonable accommodation request? It sounds like a person is allowed to get anything they request at any time. The answer is that although the right to reasonable accommodation is very broad, it's not unlimited. Let's look at what the ADA means by reasonable. First, there has to be a nexus or link between a person's disability and the accommodation they're seeking. Nexus is the legal or technical term for the identifiable connection between these two things. The basic question to ask is, does the accommodation meet a disability-related need? The nexus in a reasonable accommodation request is generally pretty easy to spot. For example, there's a clear nexus between the fact that a person has low vision and their need for large print documents, or between having a learning disability that affects a person's reading skills and their request for help with reading and understanding county forms. What else does the ADA mean by reasonable? You might be wondering if it just comes down to a subjective decision, since what might seem reasonable to one person might not seem reasonable to another. You might also be familiar with other laws that use the term reasonable to simply refer to what a reasonable person would think. But don't fall into the trap of thinking that county welfare department staff should use their own personal judgment to determine whether a requested accommodation is reasonable or not. That's not how the ADA works. We've already established that a person has to be a qualified individual with a disability, and there has to be a nexus between their disability-related need and the accommodation they request. The ADA then turns things around and tells us that if these things are true, then the person's request is considered reasonable, except under limited specific conditions. Those conditions would make an accommodation unreasonable, and the county welfare department could deny that request. So, what are those conditions? There are only two reasons a requested accommodation can be considered unreasonable and can therefore be denied. The first is if the accommodation being requested would impose an undue financial or administrative burden on the county welfare department. And the second reason is if the accommodation would fundamentally alter the nature of the program, service, or activity. Let's talk about each of these in a little more depth to clarify what we mean by undue burden and fundamental alteration. The first and one of the most important things to know is that it is not up to any individual staff person to decide whether a given accommodation would cause an undue burden for the county welfare department or a fundamental program alteration. If a client expresses a reasonable accommodation request to a staff person, and the staff person thinks that the accommodation is or might be an undue financial or administrative burden for the county welfare department, or that it might fundamentally alter the nature of the program or service, then it's time to move things up the chain of command. Why is that? It's because the ADA regulations state that in order to deny an accommodation request based on either of these reasons, That final decision must be made by the director of the department or his or her designee. No one else has authority to make that decision. And the denial decision must be documented in writing and include a statement of reasons for the denial. The written reasons have to include the analysis or explanation of how and why the requested accommodation will either cause a fundamental alteration or impose an undue administrative or financial burden on the County Welfare Department. These decisions must take into account all resources and personnel available to the department. Let's walk through the analysis using our example of a client with dyslexia who asks for help reading and understanding forms. We've established that they're a qualified individual with a disability and that there's a nexus between the difficulty they have with reading and their request for help in reading County Welfare Department documents or having them explained. So we're left with two questions. Let's say this person receives CalFresh. The question is, would giving this person extra help with reading and understanding a form fundamentally alter or change the CalFresh program? The answer is no. Providing help in understanding a CalFresh form is not going to fundamentally alter the CalFresh program, since the purpose is providing nutritional benefits. Second question, would it impose an undue financial or administrative burden on the County Welfare Department? Again, the answer is likely no. It might take a specific staff person some extra time to provide that assistance to the client, but the question isn't whether the accommodation will impose any burden. It's whether it will impose an undue financial or administrative burden, which is defined as causing significant difficulty or expense. This brings up another important point. County welfare departments have to consider each reasonable accommodation request on a case-by-case basis. So the argument that, well, if we provide this extra help to every single other person on CalFresh, or to every CalFresh recipient who asks for it, that would create a huge burden on our department. That's not the way the ADA works. The ADA says a county welfare department must do an individualized analysis for each request. So the argument that granting an accommodation request could open the floodgates is not a valid reason to deny the request. And again, if a staff person thinks a requested accommodation will or might cause a fundamental program alteration or an undue burden, it's critically important that the staff person consult with a supervisor to move things up the chain of command. Remember, only the County Welfare Department director or designee has authority to deny a reasonable accommodation request. Now, even if a reasonable accommodation request moves up the chain of command to the point where the County Welfare Department director has decided there are grounds to deny it, the process is not over yet. The County Welfare Department must still engage in good faith in what's called an interactive process with the individual to discuss alternative accommodations or assistance and determine what would be effective in meeting the person's disability-related needs. What this process looks like is probably a conversation or series of communications with the client to determine a solution that's going to work for everyone. Also important, this interactive process must be documented in the case record just like the request itself and any other information related to the request. To emphasize this point, all accommodation offers and requests must be thoroughly documented in an individual's case record. The CDSS Civil Rights section plans to issue an ACL in the coming months with specific instructions for what and where and how to document this information in CalSAWS for programs that use that case management system. And CDSS also plans to issue program-specific ACLs on reasonable accommodation requirements, including documentation, for programs that use other case management systems as well. Regardless of the system in use, the documentation must include the fact that an individual has a disability and/or has requested a disability-related accommodation, and remember, the person is not required to provide a specific or clinical diagnosis. For example, a person with dyslexia does not have to share that diagnosis with the County Welfare Department to receive reasonable accommodations related to their reading difficulty. If they say they have difficulty with reading or with understanding written communication and they need help with this, that is what should be documented in the case record. What should also be documented is any specific accommodations that the person has requested or been offered. For example, the client with dyslexia might ask for assistance with reading and understanding the content of forms and other documents, or a county welfare department staff member might observe that the person is having difficulty reading a form and offer to explain what the form says. This must be documented also. And the accommodation actually provided must be documented, including details about any interactive process discussions that took place and the results of those discussions. So for our example client who has dyslexia and needs assistance understanding county welfare department forms, the worker would document each time they provided the requested accommodation, including details such as what form or forms they assisted with. And remember that in a situation where a reasonable accommodation request is denied, that must be documented in writing with a statement by the director or his or her designee explaining why the requested accommodation imposes an undue burden or causes a fundamental alteration. Next, we're going to focus on a specific type of reasonable accommodation that helps ensure effective communication between a county welfare department and clients with communication-related disabilities. Vision, hearing, and speech disabilities can impact people's ability to communicate with others. These disabilities include blindness, low vision, deafness, hearing loss, deaf-blindness, speech disorders, and others. The ADA specifically requires that county welfare departments ensure effective communication between the county welfare department and these individuals. That is, communication with them that is equally as effective as communication the county welfare department has with members of the public who don't have such disabilities. It's easy to see why this is critically important. An individual must be able to communicate effectively with the county welfare department in order to access any of its program benefits and services. Also important, this requirement applies not just to applicants and recipients of program services, but also to their companions. The ADA regulations define companion to mean a family member, friend, or associate of an individual who's seeking access to a service, program, or activity, and who, along with such an individual, is an appropriate person with whom the county welfare department should communicate. What does this mean? It means that if it would normally be appropriate for you to talk to a client or applicant's spouse, or their child or friend or another member of their household as part of the normal course of doing business and running your program, and if that client's spouse or child or friend or other household member has a communication disability, the county welfare department must ensure effective communication with that person as well, not just with the program, client, or applicant. In order to ensure effective communication, a county welfare department may need to provide the individual with a type of reasonable accommodation that the ADA refers to as an auxiliary aid or service. Auxiliary aids and services may include things like technology equipment or written documents in an alternate format or ASL interpreter services. Auxiliary aids and services have to be supplied by the county welfare department at no cost to the individual. Let's go over some specific examples. These are just some examples of auxiliary aids and services that might be needed by individuals with vision-related disabilities. Large print documents, braille documents, documents in an accessible electronic format for use with a screen reader. And for those who aren't familiar with screen readers, this is a type of software that reads aloud the contents of electronic documents or websites word for word. Audio recordings are another type of auxiliary aid, and qualified readers can provide the auxiliary service of reading documents aloud for the individual. A quick note about qualified readers. They are defined by ADA regulations as individuals who have the ability to read effectively, accurately, and impartially using any necessary specialized vocabulary. So think about what that means in the County Welfare Department context. It describes someone who is able to read aloud written material that may contain complex program-specific terms and jargon, and to do so in a way that communicates the content clearly and accurately. These are some examples of auxiliary aids and services for people with deafness or who are hard of hearing. Note the use of the word qualified in the first item. Just like for qualified readers in the previous slide, ADA regulations define a qualified interpreter as someone who is able to interpret effectively, accurately, and impartially using any necessary specialized vocabulary. A note here about interpreters. Some individuals who have hearing-related disabilities may not be fluent in ASL. Some may use a foreign sign language or be facing extremely high stress or high stakes situations. Depending on each person's specific needs, they may require a different type of interpreter, such as a certified deaf interpreter, or other deaf intermediary interpreters paired with an ASL interpreter. Other examples of auxiliary aids and services include note taker, real-time captioning, telecommunications systems and devices, and written materials. The recently issued ACIN I-3924, titled Reminders of Civil Rights Obligations to Individuals Who Are Deaf and Hard of Hearing, can provide you with detailed guidance and information on this topic. For people who have speech-related disabilities, auxiliary aids and services might include providing a qualified transliterator. That's someone who's trained to recognize unclear speech and repeat it clearly. This auxiliary service might be especially important if the person with the disability is going to be speaking for a long time. Effective communication for someone with a speech-related disability might also involve allowing additional time for them to use an auxiliary aid, such as a communication board or other device, or providing a pen and paper if the person needs to write out certain words so staff can understand. A few more important points about effective communication. 1, the ADA prohibits counties or government agencies from charging people for auxiliary aids and services. And 2, county welfare departments cannot require that someone provide their own interpreter. If an individual wants to use their own interpreter, there are specific rules about when that's allowed and what steps are required, including the use of CDSS Form CR 6181. These rules and requirements are explained in ACL 2468 and ACIN I-3924. Sometimes there are a number of different possible ways of accommodating somebody's communication needs. Earlier, we talked about auxiliary aids for individuals with visual impairments, including screen readers, large print, braille, etc. How does the County Welfare Department know which one is the right one to provide? The ADA gives direction on how to approach this question. County welfare departments have to consider how the person normally communicates. The starting point should be what the person says about which auxiliary aid or service works best for them. In addition, in order to ensure that communication is effective, county welfare departments have to consider the nature, length, complexity, and context of the communication. That is, will the communication between the individual and county welfare department staff involve long conversations about substantive information and complex issues? Or will it be very brief or about non-substantive issues, such as providing directions? For example, passing notes may be a suitable auxiliary aid if a deaf individual comes to the county welfare department just to pick up an EBT card, for example. But passing notes would likely not be a suitable accommodation during a program intake interview or a state hearing, when the communication is complex, sensitive, and consequential. Those are situations where a service such as an ASL interpreter may be more suitable. If the person asks for a specific auxiliary aid or service, large print notices of action, for example, the county welfare department must give what's known as primary consideration to that request. That is, the county welfare department must honor that request unless an equally effective means of communication is available, or the person's preferred aid or service would result in a fundamental alteration or an undue burden. Does that sound familiar? It should. It's the same standard for evaluating the reasonableness of a requested accommodation that we discussed earlier. And the same rules also apply regarding who has the authority to make such a decision, the County Welfare Department director or their designee, and what information must be documented. Also note that even if it's decided that the aid chosen by the person would create an undue burden or fundamental alteration, it's still the County Welfare Department's job to engage in a good faith interactive process to determine an equally effective alternative way to communicate with that person. Finally, as we bring this presentation to a close, I want to highlight some additional points about a County Welfare Department's obligations. First, ACL 1945 summarizes and explains key requirements county welfare departments must comply with under disability non-discrimination laws, including requirements regarding providing reasonable accommodation. In addition, ACL 1945 specifically obligates each county welfare department to have a written policy on that topic, detailing how it complies with those requirements. This ACL provides a roadmap for what information a county welfare department's policy should cover at a minimum. However, to develop and maintain a truly robust and effective policy, CDSS considers it best practice to review and update the policy regularly to ensure its contents reflect current legal requirements, CDSS guidance, and county business practices. Also, a county welfare department's disability non-discrimination policy should include detailed information about the county welfare department's own specific business operations and procedures for receiving, responding to, and documenting reasonable accommodation requests. Relatedly, ACL 1945 also requires that county welfare departments train public contact staff, program managers, and supervisors upon hire and at least annually thereafter on their disability non-discrimination policies. As we've touched on throughout this presentation, this is a topic for which regular, robust training is needed to enable staff to comply with applicable legal requirements and avoid service disruption for applicants and recipients. Failure to provide needed reasonable accommodations can be grounds for a disability discrimination claim, even where there is no intent by an individual to discriminate. And any type of retaliation or retribution against someone for exercising their right to reasonable accommodations is considered disability discrimination and is strictly prohibited. A practical note to keep in mind when developing or updating your policies and trainings: line staff should be able to grant and provide most reasonable accommodations. Many reasonable accommodation requests are simple and straightforward, such as a request for a document in large font, or for assistance with completing a form, or for a wheelchair-accessible interview room. Avoid making the process unnecessarily burdensome or time-consuming for staff to respond to RA requests. And one more procedural best practice tip. Consider updating your county welfare department's reasonable accommodation training annually based on reasonable accommodation related concerns identified during the previous year. For example, if analysis of discrimination complaint cases against your county welfare department in the past year shows a pattern of delay in responding to requests for reasonable accommodation, or staff improperly denying or failing to recognize reasonable accommodation requests, spend more time on that specific area in the upcoming training. We can't emphasize enough how important it is to develop and provide robust, regular staff training on reasonable accommodation. Errors happen all the time across all counties. Some of the common types of errors we see include failing to check an individual's case record for reasonable accommodation information before making contact with that person, failing to recognize or document a reasonable accommodation request, and lack of awareness by reception or security staff of their role in providing reasonable accommodations. As we just mentioned, ACL 1945 requires training at least annually on this topic. That is, it's the minimum amount. We find that this is a topic for which frequent refreshers, reminders, and reinforcement are critical to ensure compliance, and also practice. Share example scenarios with staff and give them opportunities to practice and discuss how to respond. And if you have specific questions for which you'd like CRS's response, you can email those to our inbox at crb@dss.ca.gov. This brings us to the end of our very high-level overview of the ADA and reasonable accommodations for county welfare departments. We'll wrap up by sharing key resources county welfare departments should be aware of and rely on for information and guidance on this topic. I want to again stress some of the most helpful resources are available to you right now, such as ACL 1945, a key ACL that clearly explains the county welfare department's obligations under the ADA and other disability rights laws. ACL 2178, which addresses best practices for ensuring disability protections and rights in CalFresh. ACL 2465, which covers the same topic for CalWorks. ACL 2467, which addresses this topic for the RCA, ECA, and TCVAP programs, and ACIN I-3924, which includes guidance on reasonable accommodations for individuals who are deaf and hard of hearing. You can also look forward in the coming months to additional program-specific ACLs that address disability rights and access in other CDSS-funded county-administered programs, as well as an ACL that covers documenting reasonable accommodations in CalSAWS. The Civil Rights Coordinator and County Welfare Department ADA Coordinator also play a vitally important role in this area, and County Welfare Department staff should reach out to their CRCs for information, guidance, and support. For those of you who are listening to this presentation who are CRCs or ADA coordinators, we appreciate your recognition of the responsibility you have for ensuring that your county welfare department meets its legal obligation to ensure equal and meaningful access to its benefits and services for individuals with disabilities. You can also find invaluable resources on this topic from other sources, such as the Civil Rights Division of the U.S. Department of Justice and the ADA National Network. All of these resources are included in the PDF handout that accompanies this presentation, which is available on our CDSS CRS website. Thank you so much for participating in this presentation and for all that you do to meet the needs and protect the rights of individuals with disabilities. As I just mentioned, you can download a PDF handout version of this presentation from our CDSS Civil Rights section website. And remember, if you have specific questions about this topic, including how to handle or respond to a specific situation in your county, you can contact our office to request assistance by sending your query to crb@dss.ca.gov. Thank you again.